All right, the time is now 2:45 and our numbers are steadily increasing, so I will talk slowly. But my name is Anthony J. Skirbo, Attorney Advisor with the Office of Open Government, and I have the privilege of introducing a friend and former colleague here at OOG, Nick Weil, who is now heading up the appellate practice at Harvath Law Group, LLC. Nick was our in-house parliamentary procedure specialist, among so many other things, and we are very grateful and lucky to have him willing to come back and do this session for us on parliamentary procedure. Nick just stated moments ago, for those who are just joining us, that he wants this to be highly interactive, so feel free to share your questions in the chat. My colleague Brandon Lewis and I will be monitoring the chat. I'm sure Nick will be keeping an eye as well. And we'll make sure to take questions, and then we'll provide information on the parliamentary procedure training portal after Nick has answered questions. Nick, feel free to take it away.
Great, thanks. And it goes for Anthony, Brandon, anybody else. Just jump in and interrupt at any time if a question pops into chat or into your brain. I'd rather be just interrupted and be specific and helpful. If you, I dare you, I challenge you to derail me from my prepared outline and make it more specific and helpful. So having said that, on to Roman numeral 1 of my prepared outline. A quick definition of parliamentary law. What even is parliamentary law? And I say parliamentary law, by the way, not parliamentary procedure, because when people hear parliamentary procedure, I think that a lot of times they think of this, and that's fine, but it has substantive impact too. Parliamentary law does. And I always say Open Meetings Act is, at least in large part, parliamentary law. That, and DC Council procedure is parliamentary law that has substantive impact. The fact that you need 2/3 to override a mayoral veto, that's not just traffic. That's not just directing traffic. That's not just for convenience and order or decorum. That could make the difference in a substantive change in the law. So that's just an explanation for my personal preference on the term. So what is parliamentary law? My working casual definition is rules of the road to regulate the work of a deliberative assembly. What's a deliberative assembly? It's a group of people, large or small. It can be very large, thousands of people to very few, few enough to make it useful to use parliamentary law. A group of 2 or maybe even 3 people could sit around informally and reach consensus without even having a chairperson, let alone rules to guide themselves. Anybody who's ever decided where to go out for pizza knows this. You don't need, it would be inane to have somebody have to move that we go to pizza place A versus Tony's or whatever. So, but that's a deliberative assembly. A deliberative assembly is a group, large or small, that acts in concert. Maybe not everybody in the group agrees with every decision, but when a decision is made, it has the stamp of the entire group on it until it changes its mind down the road. So parliamentary law, rules of the road to regulate the work of a deliberative assembly. It's not, and this is what I'm going to focus. I've done some version of this talk before, and I'm going to focus even more on what is most relevant to DC public bodies, DC groups, I think, and really emphasize to you that even following Robert's rules to its strictest letter, there is a almost secret body of law within this that is going to save you a lot of time and that people don't know about. And I confess I only discovered myself 5 or 6 years ago, namely rules for small boards. And we'll come back to that. So parliamentary law is not formality for its own sake. It's not, I think it doesn't deserve its reputation for stuffiness. It's ensuring, it's ordering the business of a body in a way that is fair to everyone's views. But to the extent that, and this applies certainly to a lot of DC groups, to the extent that people tend to agree on everything, to the extent that people just want to move forward and get resolutions passed, get work going, I'm going to help you hopefully use some mechanisms to really get to move through without feeling awkwardly stunted by feeling like you have to follow some rigid procedure that you don't. It's a tool to work within yourself. It's not a weapon from on high that makes your group, that's supposed to make your group work slower than it otherwise would. Checking the chat here. What are the legal ramifications of using or not using parliamentary? Great question. Getting right to a core issue. Thank you, Desiree. The legal ramifications, it depends. Parliamentary laws we'll talk about in a minute. I'll move this up in my prepared outline. We'll talk about that next. What comprises parliamentary? We'll define parliamentary law in terms of what are its components. It's not just this. It has extrinsic components like the law of the governing political body, the Open Meetings Act in part, for example, or the Enabling Act that created you and prescribes how many members you've got, whether you've got a chairperson, how many times a year you've got to meet. So those extrinsic components, particularly they come from statute or regulation that are in a higher hierarchy than your internal procedures, those you've got to follow by law. They are LAW law. And if you forget, or you know, I can't tell you on a case by case basis what the implication would be. Let's say that there's a requirement that your board meet 4 times a year, and you've only met 3, and now it's December 30th. You could, given that by the way, then you're within the notice window for the Open Meetings Act. So even if you're going to meet on December 31st, you were supposed to have noticed it up already, probably. So if you get to that point, you could be subject to a mandamus lawsuit. You could be subject to, this is all hypothetical and this is all fantasy, but as a general meta sweeping answer to your question, Desiree, there can be legal remedy, including in court. And I'll just skip ahead and note that there is a federal judicial opinion that at least implicitly endorses Robert's rules as sort of the source of common parliamentary law. As far as remedies within your group, if something goes awry within your group, then it's subject to a point of order. And points of order, you're likely familiar. Anybody can raise, anybody can interrupt at any time, anybody can interrupt debate. You don't need to be recognized you don't need permission to bring the group's attention to a violation of its own procedure. And then what happens is, unfortunately, subject to the group itself. The chair may rule on the point of order. Let's say I'm coming up with an example. It's not going to be the best example, but Robert's rule, strictly speaking, provides for 10 minutes of debate per person. So if you haven't adopted something else for your own group, can someone tell me, sorry, Anthony or Brandon, how I totally don't know what time I started. How much? I'm going to go with 3:10. I'm going to stop talking unless you tell me otherwise.
Perfect.
So 10 minutes of debate is I think, if I'm remembering right, is the common law sort of debate limit. If someone's rambling on for 12 minutes and somebody says, sorry, point of order, we've been, this speaker, this member of the body, my good friend, has been going on for a long time here. And the chair disagrees and says, no, my watch says 9.5 minutes. Whether or not the chair is wrong can only be appealed within the group. If a member aggrieved by the extra 2 minutes takes them to court, they're likely to lose. I've always said I'm terrible at coming up with hypotheticals, but my point is that for as far as internal practices that don't violate some extrinsic overarching law like a statute or regulation, the remedy is within the group. Even the parliamentarian, even if you're lucky enough to have a parliamentarian in your membership, that person is just an advisor to the chair. That person doesn't sort of like in the houses of Congress, as you may know, the parliamentarian's office, they give recommendations that are taken very seriously as to which committees a bill is assigned to. But ultimately, if the speaker or the majority leader of the respective chamber of Congress doesn't go along with that, the only remedy would be for the whole body to overrule that leadership, which is a very rare political maneuver. So even the parliamentarian doesn't call the shots, formally speaking. Okay, where am I on the thing? Okay, we're talking about the hierarchy. What is parliamentary law? Extrinsic primary law. Your own bylaws will supersede, which is why I say draft your bylaws carefully and concisely, make them trim. I suggest that groups not put into their bylaws. I know they can't resist this, and I think even Robert's Rules advises that people to obviously, because they're a publication, they make money off of it. They want people to put into their own bylaws. Oh, we've got to use Robert's Rules if there's any conflict. But I would suggest that I'm going to do Robert's Rules a solid, and I think that Robert's Rules, being the compendium as it is of parliamentary common law, if there ever were a conflict or something that the bylaws didn't address, as we've even seen in the courts that have recognized Robert's Rules would be the fallback. So you don't need to put it into your bylaws. If you make the mistake of saying in your bylaws, we've got to follow Robert's Rules, then you've hamstrung yourself. And arguably, you're going to be in trouble if one day you the group wants to suspend the rules and do something that may be a little risque or arguably contrary to what you think Robert. If you leave Robert's Rules alone, let it just sit there in the background as a fallback, it's great. It can be a great tool in that case. But if you bind yourself to it, then it makes people uneasy about some of the mechanisms I'm going to skip to here so that I have time. Let me skip right ahead to the good news. The good news about most DC public bodies, and that is the rules for small boards. In the current edition, 12th edition, I think it's I told myself I'd remember this. I think it's page 464. Rules. It is good. Page 464, procedure in small boards. And this is great. These are things that if you're fewer than, and what Robert's rule says, in a group of not more than about a dozen members present, you can you can opt by a simple majority to adopt the procedure in small boards. So you're still following Robert's rules. You're just, because you've got a small enough group, which applies to the large majority of DC public bodies, fewer than about a dozen members, you're dispensing with some of the formalities that make people uncomfortable, that make meetings take longer and are frankly unnecessary. For example, under the procedure in small boards, I'm looking at section 49, paragraph 21, if you care, of Robert's rules. Motions need not be seconded. You don't have to stand up, which that's something that's always bothered me about Robert's rules, is this ableism. Technically, Robert's rules command that, I'm going to call it the whole book, big group Robert's rules commands that you stand to be recognized. Not everybody can stand, and it's awkward in a WebEx meeting to stand and you go off the frame. So the procedures in small boards, no seconds are necessary. You can raise your hand for recognition. You don't have to stand up to be recognized. You can stay seated. You don't have to stand in order to speak to the floor. Also, big one, the chairperson can participate. Strictly speaking, under the whole book, Robert's Rules, the chairperson is supposed to be neutral. They're not supposed to participate in debate. They don't even vote. unless it's a secret ballot, like you're electing officers or something like that. So, and even in the House of Representatives, for the speaker to vote for the speaker to vote in a roll call is an unusual maneuver. Usually when if you pull up on the House of Representatives, the roll call votes, you'll see each of the members listed alphabetically and then a yay or a nay next to their name. The speaker is usually left off of that list. Not only are they not abstaining, they're not voting present, they're not even there. They don't even exist for purposes of a roll call vote. And the same thing is true in whole book Robert's rules. The chair has actually less power than other members because they don't participate. But in small, if you adopt by simple majority these small board rules, then guess what? The chair is allowed to participate and get the power that, after all, most DC groups give to the chair, is having worked their way up through the subject matter expertise over time or paid their dues, etc. Okay, so we're still on I think it's Roman numeral 3 of my prepared outline. I see nothing in chat. How to keep parliamentary law from getting in your own way. Another thing is, and some of this will be repeat. If you've heard me do this before, I hate seconds. Even if you're not even if you're a big group and you can't follow the small board rules, seconds are almost always useless. And I would challenge anybody to give me a counterexample. I can't think of it, because the whole purpose of a second is to save you time having to listen to a debate on a measure that literally only one person cares about. And I see that way more time has been wasted by the awkward waiting around for somebody to second a motion that the chair reasonably knows that almost everybody is going to be okay with discussing. So if the chairperson senses that, hey, this is going to be something that everybody's okay with discussing, or more than one person is okay with discussing, then the chairperson doesn't need to wait for a second. And in the rare event that the chair is wrong, and it really is just a one-person lark, I've never seen that happen, but if it does ever happen that the chair is wrong and should have waited for a second, and now there's just one eccentric member rambling on about their own pet issue, guess what? They're limited to 10 minutes of debate, and then this nightmare, this hypothetical nightmare, will be over with. Or somebody could, guess what, stand up or raise their hand if it's no, they wouldn't be you wouldn't be following small group rules in my hypothetical. So you'd have to stand up and raise a point of order that, hey, this motion wasn't seconded, and then the chair will recognize your point of order is well taken, and the motion falls to the floor. The would be motion. Let's see here. So, and kind of related, and one more, making your meetings go faster, getting hyper formalism out of the way. I love unanimous consent. They use these a lot in the U.S. Senate and the House. If the chair senses that everybody's going to be okay with something, an uncontroversial measure, the chair can just say, and if you're in a small group procedure, by the way, the chair can introduce her own motion. So the chair could even say, I recognize that it's so-and-so's birthday. Is there objection to the group, a resolution that the group wish member so-and-so a happy birthday, and that'll be laid into the minutes. Without objection, so ordered. Happy birthday, member so-and-so. Let's see, I'm not going to get into what else can we go. I can go back up here a little bit. Oh, custom. I like talking about so the sources of parliamentary law, we covered extrinsic primary law, statutes or regulations, your own bylaws or constitution. If you're maybe getting back to the legal import, if you're a board of directors of a corporation, you probably have articles of incorporation, which is kind of like your own private constitution. And that would govern, and legally so, your duties to say meet once a year, depending on the jurisdiction, to announce that meeting to your shareholders. So those can have serious legal import as a fiduciary. Also, something that supersedes whatever's going on internally would be private law that binds your group. Like if your group meets in a library, let's say, or you rent a room at Nationals Park or something, um, you'll be subject to and they ban smoking. Then guess what? During the course of your meetings, your parliamentary law for your group is going to include a no smoking rule. And it would be a valid point of order if someone comes in and lights up. It would be a valid point of order to somebody, or actually a point of privilege, either one probably, for somebody to object to the so a point of privilege if they're personally objecting to the smoke, point of order if they're just raising the chair's awareness of, hey, we're going against what we're supposed to be, how we're supposed to be conducting ourselves in this third party environment. So extrinsic primary law, extrinsic private law is included in that. Bylaws, constitution, special rules of order, or standing rules of order. Those are things that where your group can override. I got 3.5 more minutes. Override, Robert. Let's say that you've taken my advice and you haven't commanded yourself in your bylaws to adopt Robert's rules as your parliamentary manual, but you've adopted a standing rule of order to adopt Robert's rules. That's the way you should do it, in my view. You just put it into your minutes. You decide it by a majority. We're going to adopt Robert's rules as our parliamentary manual, and that's the way it stays until either you change your minds and shift to a different one like Sturgis, or on a case-by-case basis, the body can override Robert's rules. Again, Congress does this all the time. They don't use Robert's rules, but they override their own procedural rules. They say by a 2/3 majority, which is also what Roberts requires for this, suspending the rules and doing whatever the heck you want to. So if there's a suggestion that maybe such and such a motion would be out of order, it would incorrectly take the precedence of something else that's supposed to be in the order of business. A 2/3 majority can basically do whatever they want, including override the parliamentary manual. All right, 2 minutes, and we got a question. Thank you, Glenn. Does the board have to adopt Robert's Rules of Order each meeting? Can they do so? Can they do it once a year? Again, my understanding of the parliamentary common law is that a standing rule of order is a standing rule. So you can adopt that, especially if it's a majority of the entire membership of the board, which makes sense. If a majority of the entire membership of the board is in favor of something, then you're not trammeling anybody who's not there. So in that situation, you can adopt that standing rule of order, and then it's in place until it's not in place anymore. So there's not an automatic reset timeline to answer your question. Oh, and before I run out, this is important. So we've got what? Extrinsic primary law, et cetera, bylaws, constitution, special rules of order, standing rules of order. Finally, way down the list comes your parliamentary manual that you've adopted, / parliamentary common law. Again, I would argue that even if you haven't adopted this, it slides in to fill any gaps that exist. And then at the very bottom of the list, just under the parliamentary manual, is custom. Any customs that you've adopted could become part of your parliamentary law, even if they're not written down anywhere, even if they're not written down in this manual or an order, and that could be enforceable as a point of order. And quickly, in my 18 seconds, I'm going to give you an example that I got from the British House of Commons the other day. A few years ago, the speaker was questioned. Yesterday, somebody spoke without wearing a tie. Is there an obligation to wear a tie while you address the House of Commons, and are female members prohibited from wearing a tie? Would it be a violation of decorum for a female member to wear a tie? And the answer to both of those questions is no. The Speaker said in the conventions and courtesies of the House of Commons, if memory serves, there is absolutely no obligation on female members not to wear ties. And the question of whether a member is wearing a tie is not absolutely front and center stage, though I fear this will gravely disquiet the honorable gentleman. Opinions on the honorable gentleman's choice of ties do tend to vary, but it has to be said that the same could be said of my own. Thank you very much. We'll leave time for Anthony's slides, questions, etc. You're
You're muted, Anthony.
Thank you, and thanks, Nick. Before we put the slides up regarding the portal, we'll see if we have any further questions. As always, great parliamentary. Leave my tie out of it. Nick and I have frequently sparred in debate and outside of standard parliamentary debate on various ties. So we will leave you all out of that foolishness.
I thought you might think that was directed at you, and it was just coincidentally that I happened on that as the first example of custom that I found.
Of course, and of course it was. So we'll let everybody believe that, and everybody can hear us regale them with stories of our great debates. Possibly tomorrow at happy hour, which you will see on the Ethics Week agenda at Lincoln at 5 if you choose to join us, and you're more than welcome to. I don't see any further questions raised in the chat, so I am going to go ahead and share the slides, and I'm going to start from the beginning. Here we go. And we offer to DC government employees and members of public bodies parliamentary procedure training. Under the DC regulations, 3 DCMR section 10408.2, the Director of Open Government may provide advice and training on parliamentary procedure upon request. And when Nick was here, and subsequently, we do occasionally get parliamentary procedure inquiries, and we're happy to help and advise. However, we do have, in fact, the portal, and this is to be distinguished from the portal that is used for FOIA requests. We have Robert's Rules of Order Training Portal, aka robertsrulesmadesimple.com. And here's the link, which again will be available in these slides for those to attach. And you'll see here, it's pretty small, but the basics of Robert's Rules of Order, the 7 fundamentals, etc., that is available. DC government employees and members of public bodies can send a request for portal access to this office, and it's easiest usually just to send it to our main inbox at open.govoffice@dc.gov, and one of us here will see it. So if you choose to, if you're a DC government employee with a DC government email, or if you're a member of a public body and we can verify that, then we can get you signed up for free for access to the Robert's Rules portal. And again, if you have general or specific parliamentary questions, you can reach out to this office. And if we get stumped, we'll reach out to our friend Nick as well. But once again, I want to thank Nick Weil for joining us today, and we thank everybody for joining us. It is always great to have old friends and to do open government training. So with that, unless there are any other questions, we will see you all a little bit later for our final presentation of the day by Chief Counsel Louis Neal. And that will have to do with recent advisory opinions from the Office of Open Government. So once again, thank you, Nick, and everyone have a great afternoon.
Thank you so much, Nick. We appreciate you. It's good seeing you.
Good seeing you. Thanks, Louis.
Thanks, Nick. We appreciate you doing this.
Thanks for serving on the committee, Brandon, and playing such a big role. Okay, I'm out. If anything else comes up, you know where to find me. Good seeing everybody.
Good to see you.